Welcome to this discussion as part of our Middle Eastern series. Today we're discussing private wealth disputes in a discussion sponsored by Strela Advisory. We're going to hear from Jess Miller later on, but I'm joined today by an expert panel that is going to discuss all the key issues from this topic area. In the Middle East series so far, we've covered things like investment into international real estate, succession planning, relocation and mobility, and an important aspect of succession planning is planning, preempting private wealth disputes. So we're going to unpack some of the key issues here with an international panel. To open up the discussion, I'd like to welcome back Sunita Singh-Dalal from Stephenson, Harwood in Dubai. Good morning, Sunita.
Hi, David. Good morning.
So great to see you back on this series. And we're just going to talk a little bit around in the succession planning that families might be undertaking, new structures they're looking at. Sometimes they can be hesitant or avoid formal plans because of fears of a dispute. Perhaps you could give us a sense of how some of these fears can be addressed at the outset and some of the mechanisms in new structures that can be incorporated in anticipation of some of those issues.
Sure, David. In fact, it's very interesting because sometimes we do find ourselves stuck in the middle of a paradox, and it becomes a bit of a catch-22 situation because there are members of the family who would really like to see long-term sustainable formalized plans of governance, constitutional provisions put in place for all the generations within the family, as well as new people joining the family. And then you often then have other family members who come to the conversation when you start these discussions, and the very first thing that they're unable to get by is, but what if we all end up in court together? And it's a bit like, no disrespect intended, but in the Western world, when people are courting each other in the romantic sense of the world, they say, well, shall we have a prenup? So it kind of sets the tone for family relationships, perhaps not in the best way, setting the best foot forward, but that's where we come in and we talk to families. And first and foremost, I think it's really important to understand, well, how have they resolved disputes amicably? Maybe not so, but how have they dealt with these things before in the past? In the regions that we work with and clients here in the region, where we have clients from the Middle East, Asia, Southwest Asia in particular, Africa as well, although the geographies are quite diverse, as well as nationalities, the cultural issues are the same, and that is we really want to have our private affairs kept private and resolved behind closed doors in a very dignified and discreet manner. And so there are mechanisms. I'm sure Daniel will chime in a bit later to kind of add to this, because we often collaborate on such matters. And Jenny, of course, will come in and tell us with the best will in the world what happens when it doesn't work. But mechanisms in terms of mirroring, for example, family counsel provisions that have existed informally in society. Or within a clan or a dynasty as such. Those types of mechanisms where people have the comfort factor, but more importantly, they trust the decision-making of certain family members, can be incorporated and perhaps should be incorporated as the very first step when families are working behind the scenes to resolve matters that come up. And then only if that cannot be if a dispute cannot be resolved, then only should one look to a slightly more formal method, whether it's mediation. We'll come on to discuss that later. But in a nutshell, that sets the scene of some of the issues that we have to first kind of dispel and deal with.
Well, thank you for that. But it seems like stress testing any new structure with an eye on disputes is something that you would clearly do as part of your planning process.
Yes, it sometimes gets a little tricky when you have to pose those questions, but it has to be done. Absolutely.
Thank you. Disputes might be avoided by research around the background of parties in transactions. In our planning call for this session, Sunita, you had an interesting case of a client who brought you in to undertake some research to parties prior to an IPO. Perhaps you could explain a little bit about that example.
Yeah, sure. Again, we've worked before with groups like Jess's and others in the region who just help us do a little bit of sensible housekeeping. Again, what happens is we find most of the families in the region, or rather most of the businesses in the region, are family owned. And we are now seeing a trend of capital being raised externally and businesses expanding. And by that, of course, looking at public markets to do so. But that's also combated with the traditional family that owns the business, and those family members may be very vast as such, or in other geographies. So what may be morally acceptable in certain places may not be in others. And there are great deep-rooted sensitivities to take into account before information hits the public domain. And so we do work in terms with such companies to just help manage reputations, do a bit of spring cleaning. Social media can be a nightmare in the current day and age. And actually with the pandemic, people are relying even more so on social media. So it's really important that what is out there is indeed the correct messaging, is the messaging that we want people to know and hear. And again, it's about not letting personal affairs come out into the public domain if they just aren't relevant at all.
Okay, thanks. We'll come on to that later on with Jess, but perhaps you could explain, Sunita, some of the misconceptions around resolution of disputes and enforcement in the region, and the fact that you have there's a common law system and the Riyadh Convention. Do these elements provide necessarily certainty for those undertaking structuring?
Yeah, sure. And in fact, it's something, again, it is a bit of a common misconception because of the fact that businesses here aren't just owned by indigenous GCC families as such. We do have a lot of expat families who are doing fantastically well and are contributing to the GCC as a whole. And often we do find, again, as advisors, that people want to enter into cross-border transactions or get into relationships. And again, there's this common kind of, but what if we're subjected to the onshore courts? And there's a great deal of misconception in terms of the application of what we know as Sharia law. Actually, the GCC, and in particular the UAE, has got some tremendously well codified, clear and sophisticated laws, and continues. Those of you that work in the GCC will see how much we're actually really progressing in terms of getting up to speed with other IFCs or other jurisdictions. We do have an onshore federal law system, but of course we also have, which is fantastically attractive to international investors, we have the DIFC, which was the first common law jurisdiction. The DIFC has its own codified laws as such, which are based on common law. But in addition to that, a late entrant was the ADGM, the Abu Dhabi Global Market, again with its own court system. And that again has a nuance because as opposed to having its own ADGM codified laws, it has merely adopted the application of English law. So with that comes a great degree of comfort in terms of jurisprudence, precedents, case law, and familiarity in terms of certainty of remedies and rights and contractual issues. We have also within the GCC, as you mentioned, the Riyadh Convention. And in a nutshell, that means that any of the judgments that are obtained in courts will then be reciprocally enforced and recognized throughout the GCC. And in addition to that, the UAE has also executed quite a few reciprocal arrangements in terms of enforcement and recognition of judgments with countries that it has a lot of trade relationships with, for example, India and China. On top of that, we've executed quite a few of these memorandums of understanding. I personally did quite a few when we were working with Africa, with the DIFC. So all of this helps. But what people need to understand, whether you're working and advising with clients on family matters and putting a constitutional or contractual relationship in place, or just a business contract, you can actually opt into those jurisdictions, so you can avail of those benefits, but you don't actually have to have a nexus. The DIFC, for example, is a pure opt-in jurisdiction. And I think as people get more and more familiar with that is tremendously beneficial, especially if you're advising families, perhaps, as we said, cross-border jurisdictions. It could be a family from, let's just say, the Sultanate of Oman, and a group over in Africa. There is no actual nexus to the UAE or the DIFC, but you could opt in to have that as a choice of law and then avail of those certainties.
Okay, well, thank you for that. You mentioned at the start about the use of mediation and the benefits that it has for keeping matters private. Do you find this is a popular option for dispute resolution in the region?
Definitely, definitely, because as I said, it reflects the personalized conflict resolution methods that we've taken up and are used to in the past, before we got into a more public dispute resolution forum, such as a court system or arbitration. And again, families prefer their matters to be dealt with in a very discreet and dignified manner. Having said that, it does also come with certain pros and cons. The cons, perhaps, for the next generation, they feel, gosh, we're still stuck with these people who are deciding our fate. So it's a bit of a balance. And I think in that balance, when we work collaboratively with people like Daniel and other fiduciary experts, it's about getting the right balance even on the mediation panel. So that way everyone feels it is fair and they will accept that decision as final. Again, it just stops or rather preempts, or as best as you can, heading into a more formal dispute resolution forum.
Okay, thank you. And finally, Sunita, just on from the family law arena, are you seeing an increased use of prenups, and what's the kind of context in which these are most commonly used for families in the region?
Yes, we are. I think anyone listening to this today would probably agree that very sadly, the rate of marital disputes has probably risen globally, without a doubt. It has tremendously, it's stressed us in many ways, but also you're finding that relationships are blossoming and kind of being formalized. And so people are just now becoming a little more aware and perhaps pragmatic as well. In 2020, we had a huge change to our personal status law. And without boring everyone, what I can say is that the major change in terms of prenups is the country where the marriage takes place, the laws of that particular country and the agreements entered into will be recognized here. So again, if people think, oh my gosh, are we going to get divorced in the UAE courts? That may well be the case. Unlike certain other courts, we also have a fast track system onshore, and those courts will apply those laws. But yes, we are seeing, especially where we have clients who are choosing to enter into mixed race relationships and marriages, that's something that they are now actually just approaching from a very pragmatic perspective, and they're going in with their eyes wide open, which is not necessarily a bad thing. It's just a generational trend and change, I think.
Okay, many thanks. Very, very helpful, Sunita. I'd just like to bring in Daniel Channing from Crestbridge in Jersey. Good morning, Daniel.
Hi, David, and thanks so much for having me part of this exciting conversation.
Pleasure. So we heard there from Sunita how good governance can help preempt issues down the line. What's your perspective from the fiduciary angle on how governance can help manage potential conflicts arising in the future?
Yeah, it's critically important. I think, firstly, good governance can help clarify a common vision and purpose. And that's critical as families grow and multiple next gen begin to become involved. One of the things perhaps as a misconception is that a common vision and purpose within the family doesn't preclude nuances in individual family members pursuing their own objective. And if it's well drafted, it actually means that it just avoids people pulling in different directions. The second thing is that good governance really does help to clarify the roles and responsibilities within the family. And I think that that's critical, really, again, particularly when you've got next gen coming in. I recall a specific example, actually, that I worked on for a family in the region where it was the patriarch's vision that the son would become involved in the family business. But the son was really confused because the father just hadn't relinquished control, and there was this expectation that the son was running the business, but then at the same time he just wasn't able to. And I think that that was just because there wasn't clarity communicated about, well, what role is it that he wanted the son to fulfill, and how would that interplay with the role that the father wanted. And then the final thing on governance is, and this is probably one of the most important, is that it can facilitate regular and good communication within the family. And that's something that's overlooked, particularly when it comes to tackling difficult questions and topics. And I think that giving that forum where there is an ability for a family to come together to tackle those difficult topics is key.
Well, thank you, Daniel. I think the sense of what you're saying there is that it's not about having a straitjacket which kind of limits the opportunities of the family, but something that is about regular communication, flexibility built in. It's not about having something that's overly rigid. Is that fair to say?
Absolutely, and it's also about making sure that it's regularly reviewed, because families change, the dynamics within the family change, and I think sometimes families think, well, it's job done once I've done it at the outset, and that's not the case. It's really important that it's reviewed regularly and that it changes over time to suit what the family need from that governance framework.
Okay, thanks. And what's the role of family charters, do you think, helping clients bind together around, principles and values as part of this communication process that you're outlining?
Well, yeah, I think that is very, very important. And I think that as much as possible, these charters should cover as broad a range of the family's interests and activities as possible. That's really because from our perspective in the family office space, what we're seeing is that there is increasing crossover across the family's wealth spectrum. And that means that there is joint venture investment, there is family branches doing one thing, interplaying with the family wealth within the family office. And so I think that it's very important that it's a holistic charter that covers every aspect of the family's activities and interests.
And also covers the very international nature of these families with next generation overseas or international investments. It's got to be robust in scope, doesn't it, in order to compensate for that?
It absolutely does. And I think that talking about the next gen, the thing is that a lot of them are bringing in different visions about investment. And I think that should be encouraged, and that should be included within the family's overall vision. And it's about giving them the framework to allow that to happen and handle that carefully, to make sure that they feel included, but they're not conflicted.
Thank you. And what's your perspective on how well-implemented succession planning strategy might help avoid a dispute on the death of a settled patriarch, because it ensures that family members are provided for? What's your perspective on how that can be a useful tool to prevent those disputes arising on death of a key member of a family?
So, I mean, we always say that planning for that is key. It allows a framework in place to facilitate that transfer on the passing, and in a way it takes the stress and burden away from the heirs, but also it's very unlikely that they're going to be qualified to handle that transition when it does occur. So it takes out the confusion, the uncertainty, and the complexity that can often lead to friction within the family when they are having to handle that process themselves, or handle it in a sort of unstructured or unexpected way. Obviously, the key is to get proper advice to achieve this. And my esteemed colleagues on the panel are no doubt best placed to help with that. The other thing to say about that plan is that the benefit of involving the family members in that plan cannot be underestimated. They have to be brought into that plan and it not be sprung upon them at the event with no involvement. And that's where education is critical, and bringing all of the family on that journey with the patriarch or matriarch about their succession plan. And then finally, I think that we shouldn't underestimate the benefit of structuring. And I'm sure that Jenny is going to sort of chip in with later some of the pitfalls of structuring. But as a principle, around the succession plan, the structuring can give that robust framework that can really help to take that burden and that onus away from the family.
Okay, thanks, Daniel. And finally, in the family office context, how do you manage the due diligence around investment ideas brought to the family by third parties, contacts? You know, it's a minefield, really. Is there any sense of how you might go about bringing order to some of that process?
Yes, so we deal with a lot of family offices across the globe, and the common theme is the fact that that there are a huge diverse range of investment opportunities out there, and particularly for the family office space. I think in terms of the investment due diligence process, there's three key points really, which is that the structure of the decision-making process is key. Often these investment opportunities are short notice with rapid decision-making that's needed. And so I think it's about making sure that everybody understands the process and that there are clear and defined protocols around escalation, who is involved in those decisions, and which skill set is the right ones to bring in to make sure that those are informed decisions. The second thing is understanding the risk is imperative. And we've been doing a lot of work with a number of family offices to help them implement and enhance their own risk governance framework. You can't make critical decisions without understanding the risks that go alongside those decisions. And so some sort of risk decision framework is very, very important.
Okay, many thanks. And I'd just like to bring in now Jenny McKeown, partner and private wealth dispute expert from Stephenson, Harwood in London. Good morning, Jenny.
Good morning, David. Thank you very much. Delighted to join you all.
Fantastic. So we've heard some background, some fantastic background there from Sunita and Daniel on disputes in the region. And when do you see private wealth disputes from the Middle East coming to court in London to be heard typically?
Oh, well, there are quite a few different scenarios where trustees and family members can find themselves embroiled in disputes, and I'll quickly run through a few of the more common ones. Firstly, divorce. That's inevitable. If a family members are living in London, usually the wife will typically file for divorce in the UK, because we are known for being very generous in the UK. And where family wealth is involved, the English family court will often look beyond the wealth of the couple living in London and will try and look beyond that into the structures that might be helping to fund the lifestyle. And the family court will often look to join trustees, whatever jurisdiction they're in, into the proceedings so that they can obtain disclosure of the family wealth, and ultimately may well make an order which the trustees, even if they haven't become a party to the proceedings, feel bound to satisfy, because otherwise the family member in London will have a judgment in default against him. So that's one of the situations. Another situation that I think is fairly common is where there's an allegation that the settlor has put some assets into a trust in order to avoid bankruptcy or creditors getting hold of them. And where those, as under English law, where the assets have been put into trust within 2 years of the individual becoming bankrupt, we can seek under the insolvency regime to recover the assets from the trust. But more, if it's over a longer period, it may be that the English court or the creditor is looking to the court to order that the trust is a sham, really doesn't exist, and is only there because the settlor wanted to hide his assets. Other situations, I mean, as Daniel will no doubt know, most of the large family structures for clients in the region will hold property and investments in the UK. So you might find as a trustee that you've refurbished the family home in London and the builders have done a terrible job. So as a trustee, you're required to bring proceedings against the architects or the building company who have refurbished it. So again, you could find yourself needing to put your toe into the jurisdiction of the English court. Joint ventures are another example. As Daniel mentioned, increasingly sophisticated families are entering into joint venture arrangements with third parties. And if that's a company or a vehicle that's based in London and there's a dispute between the shareholders, the trustees, as the owner of the shares in the joint venture, will become embroiled in proceedings in London. Another example that we quite often get involved in at Stephenson Harwood is claims against advisors for negligent advice. Sadly, trustees need to take, obviously, tax advice, investment advice, legal advice, and sadly, the advice that's given is not always the best advice, and trustees could find themselves with unintended tax consequences or a significantly reduced investment portfolio, and may well need to act in the best interest of the beneficiaries to bring claims against those advisors for damages. And then finally, really, it is the sort of trustee beneficiary disputes. I mean, ordinarily, unless the trust is governed by English law or the trustee is located in England, mostly those disputes will take place in the location of the trustee. So in Daniel's case, Jersey, but all over the world, really, sort of main offshore jurisdictions. And those are your sort of typical beneficiary spats where two branches of the family are not seeing eye to eye on whatever the investment opportunities they're doing, or feel that they haven't been treated fairly. And the trustee then quite often finds himself in the middle of two branches of the family, and may even face an application for removal if one branch of the family thinks that the trustee is in bed with the other branch of the family. So that really is a sort of whistle-stop tour to the sort of cases that we in London get involved in structures.
Wow, myriad of issues there. I mean, Sunita mentioned at the top about increasing popularity of mediation to keep things private and out of court. Do you see that in London particularly applied to this region?
Oh, absolutely. Families are always looking for ways to try and keep it out, and mediation is one of them. The other thing that we're seeing, and it is a little bit more difficult and depends on different jurisdictions, is trying to get arbitration as a way to settle disputes, because arbitration is totally confidential. It isn't cheaper and it isn't quicker. Mediation is both cheaper and quicker. Arbitration is neither. But if you are operating in a jurisdiction where the trust law has incorporated arbitration as a way to resolve trust disputes, that is a very useful mechanism. Another way I've seen it deployed is where the family has broken down completely and the trustee has decided that the best way to move forward is to divide up the trusts into sub-trusts or separate trusts for each family member. And there you can enter into an allocation of trust assets deeds, for example, put into it an arbitration clause for settling any disputes in relation to that allocation of assets, and sit there safe in the knowledge that going forward you will settle things by arbitration, irrespective of whether arbitration is recognized in the trust jurisdiction that you're in. But it's a very we're getting quite creative to try and find ways to keep things, beneficiary disputes particularly, out of the courts.
Okay, and arbitration is more expensive because you bring in an independent judge, or what's the differential there?
In my experience, and I've done a couple of trust arbitration, it's not just that you've brought it. I mean, you do have a paid judge, unlike the courts, and you have a paid panel of judges, so it's 3 of them. There are also very few in English court proceedings now. The courts have become very good at penalising parties for dragging their heels, for trying to get too much information. Any time delay adds to costs. Work, as we all know, expands to fill the delay. And in arbitration, sadly, there's very little control, so it can take a lot longer, and things that take a lot longer are going to cost more. And there's always one party in litigation that, for whatever reason, doesn't want to push the case forward.
Okay, thanks. I mean, and you mentioned at the top in the long list of things that might go wrong, trustees and other professionals needing to be aware of risks for them. I imagine these particularly arise in the area of tax, which is very complex and potentially expensive for clients. So what kind of disputes might arise involving the professional trustee themselves directly, and what kind of steps might they take to protect themselves from these scenarios?
Yeah, and tax is one, and investments. They're the 2 most common advisor disputes. So, for example, a settlor comes to someone like Daniel and says, I would like to have some help in structuring. And Daniel says, well, let's look at the family members, let's look at where you're resident, let's look where you're domiciled, let's take some, and you decide that there's quite a lot of nexus with the UK, for example. So you decide that you need some tax structuring advice in relation to holding properties in the portfolio, in relation to beneficiaries who might be resident in London and receiving benefits out of the trust. So you go to a law firm to get the advice, and the advice is given to the settlor, and this is what you should do because this would be beneficial to all the wider family members. And then Daniel and the settlor implement the advice, and it transpires that the tax advice that's been given is negligent, and ultimately the trustees, for example, have been faced with a tax bill that wasn't anticipated, or the beneficiaries are faced with a tax bill that wasn't anticipated. So you need to then bring a claim in negligence against the legal advisor. The problem is at the outset, the settlor, because there wasn't a structure or a trust in place when the advice was given, the settlor will be the person who contracted with the law firm to provide the advice. And law firms are pretty good at making sure that their engagement letter says, we're only responsible to our client, we're not responsible to any third parties, the third parties can't rely on our advice. And in these circumstances, the trustee, for example, if he has suffered the tax liability, could be said to be a third party, and the trustee is not entitled to rely on the legal advice that was obtained for the settlor, which led to the creation of the trust. The beneficiary, a third party, might not be entitled to rely on the advice because they're a third party, but ultimately they are the person who the trust and the structuring was created to protect because they're resident in the UK, and they are the ones with the HMRC liability. And again, the law firm might well say, well, they weren't our clients, so we're not responsible to them. So I think the message to trustees is make sure when you sit down and instruct a law firm, or your client does, that you've thought through who might need to rely on this advice, and more importantly, who might suffer a loss if the advice is wrong. And I've seen situations where the law firm has tried to blame the trustee for not taking its own independent advice at the time the settlement was created. But that's ridiculous, because then you've got one law firm advising the settlor, telling him to set up a trust, and then the trustee saying, well, actually, before I do that, I just want to check that the advice that you've been getting from that law firm is correct. So it just doubles up on the legal fees. So I think it's really just taking a step back, and actually, rather than just signing up to a law firm's standard terms and conditions, push back and say, it's not just the settlor who, in fact, it's rarely the settlor who will suffer the loss. It's actually the trust, or it's the beneficiary. So really push back and give thought at the outset as to what might go wrong.
Many thanks. And what are some of the considerations around enforcement of judgments in the region? We heard from Sunita about common law in the jurisdiction and the Riyadh Convention. What's your perspective on that?
Well, I don't practice litigation in the UAE, but we do have, Sunita has some great colleagues out there who could probably talk for hours on the enforceability of judgments in the UAE. From my perspective, the sense I get in London now is exactly as Sunita has said. The situation's improving all the time. I mean, historically, we always viewed the UAE as a challenging place to enforce judgments because, first of all, you needed an international treaty, and sadly, there isn't actually an international treaty with England, although there is a memo of understanding. And second of all, even if you did have a treaty, there could be a long-winded challenge to the judgment, which could take years before it reached the Dubai Court of Cessation. I think cassation, is that how you call it, Sunita? And that could be very expensive. And that could be very expensive. So it was a region where you thought, oh goodness, no, this isn't going to be easy. But with the DIFC law and the fact that the DIFC courts are required to recognise and enforce all foreign judgments, that's really, really helped. And that's a route into enforcing then through the local courts. And the other thing to recognise is, because you've codified in the DIFC your trust law, as Sunita was saying, to create sort of a common law jurisdiction, you have common with most sophisticated offshore trust jurisdictions introduced your own firewall provisions, and I think they will give comfort to some settlors of structures for some of the things that I was talking about. So in England, you might well have a decision that says the trust was created as a sham or was done in order to protect assets for creditors. But actually, those are things that you will need to have a look at when it comes to enforcing in UAE, because you have some firewall provisions that say an English court is not entitled to determine that. You have to come and determine that in the UAE.
Okay, thank you. And finally, Jenny, we heard from Sunita and Daniel how mechanisms can be included, good governance can help head off disputes, but they clearly do still arise. Does the death of a settlor or subsequent intergenerational transfer of wealth often bring about a dispute, despite the good intentions on creation of a new structure?
Thankfully, not often. I think, it inevitably brings about tensions. And a good family charter, which I think both Sunita and Daniel were discussing, is the best way of heading off those tensions. And I think a family charter doesn't need to be negative. It needs, in terms of this is what will happen if a dispute arises. I mean, when I draft family charters, that's usually the back end of it. It's more about ensuring that every branch of the family and every future generation feels that they've had a voice and that they've got a mechanism to input into the way they want the future family wealth run. And I think this is particularly important because younger generation are so interested in things that older generation just weren't, and ethical investment as being an absolutely classic example. And I think that if the younger generation feel that they have a voice into the direction of the future of the family wealth, they're less likely to have those simmering tensions at the fore when the settlor dies. But ultimately, sadly, they do arise. And I think if they do arise, we always put in the family charter a sort of mediation type route with trusted family members, some independent people, so people that you feel that every branch of the family would trust to come and sit in sort of, as Sunita described it, as a mediation type counsel to try and resolve the dispute. And I think if you get buy-in at the outset to all the family members of the family charter, then it's less likely to spill over to an actual dispute. But the other thing is I would urge is you do need to keep updating them because families keep changing. So there's no point in putting in place a family charter at the outset of the chat and then putting it in the drawer, and then 20 years later the settlor dies and you pick it up and you go, actually, this has got very little relevance today. So I always think that they need to be reviewed regularly and discussed regularly and openly with the family.
Perfect. Well, thank you very much for that, Jenny. And just to bring in Jess Miller from Strela Advisory. Welcome, Jess. In terms of due diligence around parties to investment, we heard from Daniel and Sunita how this can crop up in structures. How can families protect themselves against fraud?
I mean, first of all, you want to understand who you're dealing with and exactly what you're investing into, and you can build kind of a pretty good picture from every source of kind of publicly available information, and then also supplementary human intelligence around your investment partner or investment or acquisition. In particular, you want to be looking at whether there is veracity to any kind of claims and statements that are being made to the family by anybody who is seeking investment. Simply, is what they're saying true? From if they claim to be X to have worked in a particular place, can we verify this? Right down to if it's depending on the sector or what kind of asset you're investing into, if you're supposed to have particular permits or licenses or a company's bidding for something, can we verify that this is the case? Or is it not? Is it all a fantasy that's being pitched to a family? What is also less of a fraud issue, but more around reputation, and I know we will discuss this in a minute, but where you have families who are really sensitive about security and privacy and their reputations, does anyone coming for investment that wants to partner up with a family office or seeking their investment, do they align with the values that the family holds and effectively align with the family brand? And will the investment itself also fit naturally into a portfolio that is focused on family values and reflecting the decision of the family into where they want to be putting their money? And Daniel's also picked this up, where the difficulty can be is outside of the family office, where you have individuals making direct wealth investments. This can be more of a sticky issue because it can be projects being pitched or investment being sought on the basis of personal relationships, or introductions through parties that are friendly to a particular individual. And in the kind of the Middle Eastern more personal way of doing business doesn't necessarily align with the more formulaic and kind of clinical background check due diligence procedure. And there you need to, what's really helpful is if you have a kind of trusted advisor to the principal, or some kind of family office quarterback who's just sort of that point person for what's going on within family office, for them to actually take up the mantle of bringing in investigators or conducting some of their own very subtle inquiries, or doing it through third parties if they don't want the family to be openly seen to be doing something, because they're the ones that are best placed for having that conversation around, okay, maybe this isn't quite right for you, and ultimately protecting the family more broadly from issues around fraud or unaligned investments.
Okay, thank you. And how might you assist a family to trace assets where they are the victim of fraud?
So asset tracing is basically pointless unless you're really focused on recoverability. Some kind of voyeuristic exercise to sort of, map out the nth degree offshore company that you don't even know what it does really isn't helpful. So it's asset tracing. You need to focus it on recoverability and understand where, if you're working with forensic accountants, exactly where the money has gone. And if you're working with investigators, looking at tangible assets at the end of the chain. So then when you're working with the instructed law firms, you can come to a consensus on what jurisdictions are going to be most important. Or if you're trying to keep everything more in-house and try and resolve this through some sort of negotiation, you know where the points of leverage are for your counterparty, you know what jurisdictions, what they're owning, how important it is to them. And then what is extremely helpful actually in these investigations is the clients themselves. Because if it's, say, somebody who's very close to the family who's done this, or if it's an investment partner, they may have had quite a strong personal relationship with the client or with other individuals in the family office or any other kind of advisor. And that information can really guide an investigation when you're looking at assets. So if you know that somebody is frequently traveling to X jurisdiction, or they've been holidaying frequently somewhere, they're the kind of places that you want to be looking, rather than you trying to take as broad a view as possible. If you can get leads into particular jurisdiction, it makes an asset tracing exercise much more useful, frankly. And then the last bit is, if it's an internal fraud, then you have the capacity to go in and review laptops, look at communications, that you can look at paper trails, you can go through invoices where you see payments go out to some really generic sounding company. You think, oh, what is that? And then you can look into it and think, okay, actually, was this being used by the fraudster to siphon off funds for whatever it is? So there's a wealth of different avenues that you can pursue to try and recover assets, but it comes down to kind of thorough investigation, working closely with your clients to capture as much information as possible, and overlaying as much sort of personal context as you can about your counterparty.
Okay, thanks for that. And in the pre-IPO example that Sunita referenced at the top, what kind of research could be conducted into parties in a transaction in the region?
So if you're IPOing a family business, I guess ultimately you're IPOing the family. And Sunita touched on the difference in lifestyles that may be held by different people across the family, may have slightly lifestyle differences, different risk appetites, different views on PR or brand or whatever it is. And you need to make sure when you're looking at the public profile of all these people that there is a kind of fundamental alignment, and that no one is saying something that is going to maybe spark a family dispute, which later down the line is going to be really bad for the investment or create issues for the family ahead of an IPO in terms of how they're perceived publicly. You need everybody on the same page. Likewise, if individuals are making their own direct investments, you kind of want to have a check about how those companies are doing, depending on the level of input even that the principal might be having in each one, because it's telling if somebody has a bunch of direct investments and they're not really that successful in the context of an IPO of a business. If your past behavior indicates your future behavior, that's not great. So you need to make sure that these potential problems or potential kind of flashpoints are being picked up before you really put the family out there and have them subject to regulatory reputational scrutiny as you would in an IPO.
Okay, thanks. And how might families consider the risks from family members' use of social media?
I think that, or rather, it's been touched on a little bit in this conversation, but when you're looking at reputation concerns in relation to, and this is really specific to GCC families, is to start from the fact that wealthy families, extended sovereign families, all have a really prominent role in upholding and kind of embodying the values of their society and their nations. It's incredibly important, and family values, family image, and societal norms and values are really inextricably linked in a way that is, not just so different to how we're able to conduct private business, or it's very specific to, I think, to the GCC. And even if different family offices are going off and specialize in particular sectors or particular assets, that this their role in society is pretty much fundamental to all of them. And what has always been the case is that families are in tandem really quite global. So people coming here to study or living, you have assets in London, more kids are in Geneva, people going off to university all over the world. And that duality wasn't so problematic previously because there was no social media, there was no massive exposure of how people are living. But so what social media does is just really elevate the potential for families to be, and individuals to be, subject to way more scrutiny than they ever have been before, and also creates risk to family security. On the one hand, through emerging issues like deep fakes and Instagram extortion and issues like this. And then at the same time is the overexposure of information around where people are living, what they're owning. Are you putting up pictures saying you're in London and you can see somebody is wearing an astronomical amount in jewelry and things like that? So what families need to consider, all of them collectively, is that the landscape can be completely changed by the advent of social media. And on the one hand, the issues can be damage to family reputation, to societal standing. And then the other one is on more personal risk, when you do have people going, back and forth, or living all over the world and posting all this information about themselves.
Thank you for that. And I mean, what are some of the practical steps that families should consider around managing reputation online? You touched on a few of the ideas there, but it'd be great to set out some ideas that they might consider.
Sure. I think that as both Daniel and Jenny and Sunita were all mentioned, it's the importance of bringing in the younger generation who are maybe more overt, more engaged in social media, in becoming full stakeholders in the family brand effectively, and in the family reputation. And from that, then you can have awareness and secure, ideally, that buy-in from all members in terms of what is being posted, what is being said, what you're tweeting, etc. Because the the key issue is if you have any kind of disenfranchisement or a massive overexertion of control by the more senior members of the family onto the younger generation, if they don't feel that they are being fully recognized or included, then what you're doing is maybe creating a series of short-term problems, but you are storing up a massive long-term problem in terms of family dynamics. And bringing in, securing that kind of buy-in over why there needs to be some kind of control, why you can't say or do what you want publicly, on Instagram or on Twitter, is really important. Where it is the case that you've secured, 99% of everybody's on the same page and maybe one person isn't. What can be really useful, again, is back to this idea of having, or there being, the key advisor, the point person, that one very trusted third party who can at that moment step in and kind of relay that message, because then what you're doing is avoiding any kind of, don't you tell me what to do dispute with the patriarch or any other kind of senior members of the family, and you're allowing people to save face effectively with this kind of more discreet approach. Practical terms, making sure everyone harnesses all of the security features that they have on all of their social media. So you're limiting the possibilities for hacking. You're making sure that you're perhaps not being publicly followed by everyone, that you have some kind of control over who has access to photos or all your videos or whatever. And also, I think education, obviously it depends around the amount of exposure the family unit collectively wants, whether they have their own comms advisors, for example, but education over effective use of social media. So teaching individuals how they can blend their personality and their family values. If they do want to carve out a niche for themselves and have direct investments, there's a way to harness social media, which actually ties into that really nicely. But you need that a little bit of kind of education and parameters around how you do it. And the last point is around a little bit of monitoring on behalf of the family of what everybody is up to, so that you can capture a problem before it really has the chance to blow up. So if somebody really is going off and posting a whole bunch of stuff that is going to be damaging, firstly to themselves and to the family more broadly, it can be removed, it can be edited. You can catch that very quickly.
Okay, many thanks. And just before we open up for questions, I'm just going to come to each speaker for their headlines from this session, from the discussion that we've had, that's covered a huge amount of ground. So Sunita, perhaps I can come to you first. What are your key takeaways from this topic area?
I think the key takeaways from this topic area is pick your advisors very carefully. But most importantly, pick the advisors that have the awareness of familiarity with the entire length and breadth of the family, who aren't afraid of asking the precarious kind of sensitive questions, but also are aware of the future plans of the family, the growth of the family, and just communication within the family with the advisors. So continual dialogue, as everyone has been saying today. A family evolves and the conversation must evolve too.
Okay, terrific. Thank you, Sunita. Daniel, what are your key takeaways from today?
I think that obviously good family governance, good risk governance, and good succession planning is key, but it's about reviewing that regularly, keeping it up to date and relevant to the changing dynamic and circumstances of the family.
Okay, thank you. Jenny, any thoughts before we go for questions?
No, and just from me is engagement. I think that's what we were all covering. It's the importance of engagement with all branches of the family. Don't just have all your discussions with the dominant patriarch.
Okay, thank you. And Jess, any closing comments before we open up the floor?
I don't know now everyone else has taken governance and choose your advisors well. I think it's important to understand where your vulnerabilities are, both obviously governance, but also around reputation. And I think really securing family buy-in into those things is so important, because having everybody, or as many people as possible, enthusiastic, involved, and feeling valued and appreciated kind of within that family unit when decisions are being made effectively about them and their futures is really important and can stave off some very personal disputes, both in the short and long term.
Many thanks. We look forward to taking some questions now from our audience live.